Succession, Articles 820 to 834 of the New Civil Code. This is Part 3. Article 820. Any person of sound mind and of the age of 18 years or more, and not blind, deaf, or dumb, and able to read and write, may be a witness to the execution of a will mentioned in Article 805 of this Code. Article 821. The following are disqualified from being witnesses to a will. 1. Any person not domiciled in the Philippines, and 2. Those who have been convicted of falsification of a document, perjury, or false testimony. Based on the preceding articles, the following are the 6 qualifications of witnesses to wills or requisites for competence to be a witness. Number 1, he must be of sound mind. This is the ability to comprehend what he is doing, same as soundness of mind for contracts. Number 2, he must be at least 18 years of age. Number 3, he is not blind, deaf, mute, or dumb. Number 4, he is able to read and write. In other words, he is literate. Number 5, he must be domiciled in the Philippines. And number 6, he must not have been convicted of falsification of document, perjury, or false testimony. Article 822. If the witnesses attesting the execution of a will are competent at the time of attesting, their becoming subsequently incompetent shall not prevent the allowance of the will. Competency or capacity to be a witness is determined at the time of witnessing. This is the same rule in testamentary capacity. Article 823. If a person attests the execution of a will, to whom or to whose spouse or parent or child a device or legacy is given by such will, such device or legacy shall, so far only as concerns such person or spouse or parent or child of such person, or anyone claiming under such person or spouse or parent or child, be void unless there are 3 other competent witnesses to such will. However, such person so attesting shall be admitted as a witness as if such device or legacy had not been made or given. Under this article, the witness, his spouse, parent, child, or person claiming under any of them cannot inherit. The exception is if there are 3 other witnesses to the will. For example, the testator is A, and the witnesses are B, C, and D. In the will, A makes a legacy in favor of B, giving him a car. Does it disqualify B to be a witness? No, it doesn't disqualify B to be a witness, but B is disqualified to inherit. The legacy is void. However, if there are 4 witnesses, the legacy in favor of B is valid because there are 3 other witnesses. Article 824. A mere charge on the estate of the testator for the payment of debts due at the time of the testator's death does not prevent his creditors from being competent witnesses to his will. Article 825. A codicil is supplement or addition to a will made after the execution of a will and annexed to be taken as a part thereof, by which disposition made in the original will is explained, added to, or altered. For example, a will states, I give my car to A, July 2, 1995. Because I want to clarify which of my cars I am giving to A, I subsequently make a codicil stating, in my will of July 2, 1995, I gave my car to A. I want to clarify that I am giving him my BMW with plate number ABC1234. Hence, when is a subsequent document a codicil, and when is it another will? It is a codicil when it explains, adds to, or alters a provision in a prior will, and it is another will if it makes an independent disposition. For example, June 1, 1995, I give my car to A. July 1, 1995, I give my house to B. This is a second will. Article 826. In order that a codicil may be effective, it shall be executed as in the case of a will. This article states that a codicil requires the formal requisites of a will. Article 827. If a will, executed as required by this code, incorporates into itself by reference any document or paper, such document or paper shall not be considered a part of the will unless the following requisites are present. 1. The document or paper referred to in the will must be in existence at the time of the execution of the will. 2. The will must clearly describe and identify the same, stating among other things the number of pages thereof. 3. It must be identified by clear and satisfactory proof as the document or paper referred to therein. And 4. It must be signed by the testator and the witnesses on each and every page, except in case of voluminous books of account or inventories. What documents may be incorporated? Generally, the documents that clarify provisions in the will to which it is attached. For example, inventories, sketches, books of account. Can a document contain any testamentary disposition? No, because they do not conform to the requirements of wills. So here are the requisites for incorporation by reference. 1. The document must pre-exist the will. It must be in existence when the will is made. 2. The will must refer to the document, stating among other things the number of pages of the document. 3. The document must be identified during the probate of the will as the document referred to in the will. And 4. It must be signed by the testator and the witnesses on each and every page, except in case of voluminous books of accounts or inventories. Article 828. A will may be revoked by the testator at any time before his death. Any waiver or restriction of this right is void. One of the characteristics of a will is that it is ambulatory. It is not fixed. It is revocable. Revocability is an essential requisite of a will. So any waiver or restriction of this right is void. There are no exceptions to this rule. Article 829. A revocation done outside the Philippines by a person who does not have his domicile in this country is valid when it is done according to the law of the place where the will was made or according to the law of the place in which the testator had his domicile at the time. And if the revocation takes place in this country, when it is in accordance with the provisions of this code. So how do you revoke a will, and what law governs the revocation? The answer depends on where the revocation is made. It can be done outside the Philippines or inside the Philippines. If done outside the Philippines and the testator is not domiciled in the Philippines, the governing law is either the law of the place where the will was made or the law of the place where the testator was domiciled at the time of the revocation. On the other hand, if the testator is domiciled in the Philippines, the governing law is the Philippine law because he is domiciled here, or the law of the place of revocation. Meanwhile, if the revocation is done inside the Philippines, naturally, the governing law is the law of the Philippines. Article 830. No will shall be revoked except in the following cases. 1. By implication of law. 2. By some will, codicil, or other writing executed as provided in case of wills. And 3. By burning, tearing, cancelling, or obliterating the will with the intention of revoking it, by the testator himself or by some other person in his presence and by his express direction. If burned, torn, cancelled, or obliterated by some other person without the express direction of the testator, the will may still be established and the estate distributed in accordance therewith if its contents and due execution and the fact of its unauthorized destruction, cancellation, or obliteration are established according to the rules of court. Article 831. Subsequent wills which do not revoke the previous ones in an express manner annul only such dispositions in the prior wills as are inconsistent with or contrary to those contained in the latter wills. Article 832. A revocation made in a subsequent will shall take effect even if the new will should become inoperative by reason of the incapacity of the heirs, devises, or legatees designated therein, or by their renunciation. Article 833. A revocation of a will based on a false cause or an illegal cause is null and void. Article 834. The recognition of an illegitimate child does not lose its legal effect, even though the will wherein it was made should be revoked. One of the ways of recognizing an illegitimate child is by way of a will. Even if the will is revoked, the recognition remains valid. Recognition is irrevocable because it is not a testamentary act, but an act which under the law admits a relationship of paternity. This is the end of part 3.